you can.
Well, it's been fun.
That's it? Your half day is over?
That's it for today. I'll be back tomorrow.
See you later. Closest one is starting.
Okay, do you want to make the card for like the correspondent by chance?
No, I have to ask him. Can you ask him?
No, there's one. Actually, I got it all in case.
All right.
Online, and the phone number right there, you're right
Oh.
This is the active service from Andy Miller at the Washington Bar Association. This is the Washington Bar Association considering on the appeals office in the federal circuit. It's Ryven versus Winky, docket 191532, April 20th. And that's April 20th, 2020. Judge Raymond T. Chen. Areas law, government administrative law, legal, ethics, military law, public benefits. And that's Attorney Raven responded, and Vernon Cook claimed the disability review on the benefits for agreement provided contingent fees complicated. Of course, to the COVID-19. Mr. Jay Inslee and also the service agency on YouTube, Facebook, and service evidence for the Donald Trump, and also as he acts up, of course, because I'm in the limousine and their services and present service when they're getting married. So anyway, their services increments on the civic past due disability benefits on the service, providing a continuing VA withhold the fee the past due benefits awarded the pay amount to carried in Raven under 38 U.S.C. 5904. D3. Within the 2 days of signing agreement, Raven sent a copy of the board veterans appeal was stamped December 11, 2009. The copy of agreement submitted in regional office, and this is the marriage of marriage of Donald Trump and Melania Trump. And the regional office are within their 38 situations. This cross-bar association where they sit the cross-bar association here is Havoc 38 SV 1463H4. Word of Cook past due of benefits April, and this check that was issued to Mr. Senator McCain and Megan McCain and Roberta McCain. This check was issued in cash, so this Raven execute for the VA Affairs 38 U.S.C. 5904D3 within days of execution agreement. Raven sent a copy of board veterans appeal. The billions, the trillions of money trimmed to Mr. Senator McCain, Roberta McCain, and also the services of increments from Arizona regional office are within 30 days. They executed at 38 SCFI 14636H4 RO Word Cook past due benefits of April 10th, April 13th, 2000, and RO attorney fee coordinating search for attorney fee agreement determined that attorney fee decision required. Retroactive benefits may be paid directly to veteran RO paid to past due benefits in Cook, April 27th. This record reflects Mr. Eugene F. Pratt, Vietnam vet, towards Vietnam, Mr. Senator McCain, Vietnam, towards Vietnam, also picking up his service, his increment service, April 2010, April 13th. This is the retroactive dates. Raven versus Winky, docket 19-1532, April 2020. Judge Raymond T. Chin, areas law, government, administrative law, economics, administrative law, public benefits. Veterans Court Federal Firm Board Denial Raven Claim, Section 590D3. This is on Google, Facebook. As you can see, this live feed, Andy Miller, Washington Bar Association. And thank you for this upgoed service. It says 5904D3 does mandate withhold direct payment. 38 CFR 14.636H4 subsection requirement invalid. Raven's fee has been forfeited and many available remedies obtained from Cook per the agreement. That's an action. That's a live feed. That's Eugene Pratt, also effective retro feed. So that's Senator McCain and Roberta McCain, active service members. Signatures, affidavits, FedEx, USPS signatures, coordinating services at 7112 West Okanagan Place, Kennewick, Washington, 99336. Red line. Supreme Court, Georgia opinion, Collins versus Georgia, docket S20A05158, April 2020. Judge David E. Nemes, areas law of constitutional law, criminal law. Pilot time Collins was convicted on felony murder conviction with stabbing death of 14-year-old Rob Reuben Hand. Reuben Hand friends gathered to watch the Peach Group New Year's Eve 2010. Disagreement ensured the Hand was stabbed near the 5 Points of March station shortly after midnight. Appellate earlier argument appeal was the trial court plea erred and gave the state's requested instructions of revenge of prior wrong, seeing the error much less error by Georgia Supreme Court. Eward versus Georgia, docket S20A0399. April 2020, Judge Peterson, criminal law, constitutional law, criminal law. Lauren Henry convicted jury of malice, murder, possession of firearm during possession of felony conviction of 2007 shooting death of Raymond Rogers. Hayward argued the appeals of those convictions. Trial court denied request to charge jury of voluntary manslaughter. Review. Georgia Supreme Court determined trial court refusal to give the charge of harmless sense of crime estimation of the realistic probability of jury would accept the slight evidence of voluntary manslaughter in light of strong evidence of malicious murder. Howard v. Georgia, docket S20A089819. Judge Keith R. Blackwell, areas of constitutional law and criminal law. Kenneth Howard was tried and jury convicted of murder by Emily Ann Smith Newbin. However, appealed, contending evidence was legally insufficient and sustained conviction. Upon reviews, record, and briefs in Georgia Supreme Court, found on merit claim on error of affirmation. Keller versus Georgia, docket S20A0006, April 2020, Judge Boggs, area law, constitutional law, and criminal law. Randy Keller was convicted of felony murder and related crimes arising outside beating death of ex-wife, 2-year-old son. William Paul appealed, raised his numerous claims of error, including effective injustice, assistance in counseling, trial, ruling motions before during trial, several inventory rulings alleged bias as a part of trial court, however, founding reversal error of Georgia Supreme Court. Mills versus Georgia, docket S20A0364, April 2020, Judge Ingleton, areas law, constitutional law, criminal law. Roger Mills was found guilty, jury of Mills, malicious murder, aggravated assault, convicted in the death of Monsieur Garrett. Mills contended to the trial court erred in during deliberation, excused on holdout juries without sufficient inquiry and good cause. After review, Georgia Supreme Court reversed the concluded evidence presented by a trial court. Legal sufficient support convicted the state could retry Mills if choose or otherwise choose so. Moore versus Georgia, S20A0344, April 2020, David E. Nummus, Constable of Criminal Law, Appellate Casualty Moore, proceeding pro se, appealed trial court denial motion set aside September 27th, ordering to deny motion for out of time appeal. 2010 resentencing 1970 convictions of murder and rape, considered, and this contended the trial abused discretion by denying the motion denied. Proper notice of September 2000 court finding records supported the trial court. Georgia Supreme Court affirmed. Morris versus Georgia, docket S20A017, April 2020. Judge Bethel, area law, criminal law. Joseph found guilty in jury malicious murder. Offenses convicted shooting death in James Bush. Morris appealed, arguing to deny the right of timely appeal. Trial court restricted VAR, alleged belief in connections and potential jury's trial court error denying confusing by jury charge regarding statements co-conspirators. Trial court error by violating the violate of public trial, ordering the courtroom doors to close and lock during the court charge. The jury trial conviction of effective sentence objection closure. Rick versus Georgia, S20A0127, date April 2020, Judge Harold D. Melton, constitutional law, criminal law. Bergman was convicted of jury malicious murder and related firearm offense of connection shooting death for William Carter Jr. Rickman Carter. Had tremendous and Thomas on again, off again relationship with a history of verbal physical abuse, false accused assault, sexual assault, empty threats of obtaining temporary predicatory, numerous calls of 9/11, 9/11 days leading to Carter's death. The pair of talking and meeting again despite receiving breakups. On 9/11 calls, officers from Rickman's residence respond telling shoots were fired. Rickman's respond holding the small dog, her wet pajamas, and also appearing injured and nothing home, looked scared and off the place. Rick told officers he was raped, and again he was shot, and the gunshots, or multiple gunshots to his body. Officers found Carter laying face up in the bed, naked with multiple gunshots on his body. Autopsy revealed Carter was shot 10 times, 4 times in the chest, 3 times in the back, once in the arm, and twice in the head. Rickman examined compliance and testified that the found injuries of Rickman in consent description event of no signs trauma or vaginal cavity. Vaginal appeal of convictions argued was denied effective assistance counsel, and the trial court erred made improper characteristic evidence, and also Robinson versus Georgia, docket S20A0265, April 2020, Judge Peterson, area constitutional law, criminal law. Her round appeal convictions, malicious murder, armed robbery, possession, armed firearm, possession, no weapon, no something, no warrants outstanding. Once again, the services and it's going to come out in your face, your mouth, and inquiries, and also your false information documents of this documented services. Mr. Robertson failed to show effective assistance counsel, verbal, and trial court in Georgia Supreme Court as they pull all the administrative purposes of scar tissue to Andy Miller's office. It's online. Washington Bar Association. United States Court of Appeals, Second Circuit opinion. United States versus Cotto, docket 182970. Judge Lovell, area law, criminal law, conviction of retaliating against a witness in violation 18 U.S.C. 1513 does require government provisions and proves the defendant had knowledge of the federal statute of proceedings, Second Circuit, rejecting definite arguments contrary to affirmed conviction and retaliation against witnesses. The court remanded revision of provisions, sentences, abuse, treatment, condition, and supervised release instructions. District Court consider remanded by the court forthcoming under United States versus Trafficking, number 18-1962, second circumstances, submitted October 25, 2008, requires modification of risk notification provisions, supervision release, and grant parties leave, reinstating appeals, and permit review of district court's decision on remand with risk notification provision. U.S. Court of Appeals for Seventh Circuit opinion. Lude versus City of Rockford, docket 19194, April 2020. Judge Ronover. Area law, civil law, constitutional law, criminal law. London required Rockford scanner held by a police officer of multi-traffic stops in Midtown. He did not have a driver's license. So he rode a motorized bicycle in Midtown to take photographs. He was suspected as prostitution sting operation, and Officer Ludd radioed to the team. Officers Welch and Campbell knew the Ludd's previous anti-police speech, directed Ludd to move to Ludd, asked him breaking any of the laws. Campbell informed that he was continued to present unconstitutional of police detail results in arrest. None in his bicycle called out Ludd, goodbye officers. Concerned Ludd might be post pictures on social media and while sting operation ongoing creating danger, unarmed, uncovered officer. Officer Ludd and arrest and driving the wrong way on a one-way street, operating a vehicle without insurance. A police officer found the aggravated driving, a revoked license, operating a motor vehicle without driving. News stories listed in arrest and substitution. See, if this guy had no warrants for arrest or outstanding warrants for arrest, and he had multiple witnesses of him battering and beating him up and taking his money and credit cards and services, this increment went escalate in Seventh Circuit and simmering judgment service very reflected on criteria information on the blood results and his whereabouts and services, returning back to the police station, returning back to the city hall, returning back to the administration, and also the residency services at the Superior District Court and federal courtroom, and also the judge administration office, and also the scanners and services. This guy carried USC 1980 stat, the First Amendment, retaliation and listed prostitute services, and also the anointed case. This is online. Docket 191945, April 2020, Judge Runover, Civil Rights, Constitutional Law, Criminal Law. See, this is a petty increment services. Since this service continued to be increment services and increment services, this is a COVID-19 update, law, research, related, and coronavirus. It's online. Andy Miller at CEO Ben launched in the U.S. U.S. Court of Appeals, 10th Circuit, Barnett versus Hall, Estelle, Harvard Gavel, docket 185090, April 2020, Judge Harris L. Hartz, area law, civil procedure, civil rights, plaintiff correspondent Barnett appealed dismissal of prejudice based federal civil rights claim for failure to state the claim, dismissing the prejudice state law because of the survivor of restriction imposed by Oklahoma Rescission Act, OCPA. Oklahoma Stat 12 Section 1430, 40 defendants cross appealed to district courts for denial of attorney fees under OCPA, contend the award of attorney fees mandatory. Barnett's complaint bases the claims on incident January 4, 2008 related in hearing Oklahoma State College, according Barnett, two lawyers and firm Hall and Sterling Hart, Gab Nelson PC. Hall and Sterling falsely reported to the Office of State Attorney General, AG Barnett, a threat. AG office and relying and replying county. Sheriff Wentbury arrived in county court hearing. The county judge instructed to speak to him. Sheriff Barnett denied making any attorney deputies hold stay in the courtroom and receive permission. AG's office arrived in its own security detail proceeding. The state court judge discussed Hall State University TU, alleged federal civil claims under 42 U.S.C. 1983 state tort claims because he's been unlawfully seized when he was forbidden by to leave the courtroom, and he's been cast to a false light of public array of alleged threats and been arrayed against the defense and exercise the rights of free speech. Exit course reviews 10 amendment affirmed dismissal of federal law claims, agreed district court complaints and defendants action under color of state of law, but court reversed judgment of state law, remanded to district court resumes prejudice and remand. Protester with a badge and uniform soliciting information and downloading system on Microsoft program services on Washington State Bar Association. It has a correct address, summaries of service for newsletters and covering for United States of America, all 50 states. This is George Washington. This is Washington State, Washington Bar Association, Andy Miller at CO Washington, Andy Miller at CO-1 US. Soviet update, laws and legal research. It's 1:48 p.m., April 21st, 2020. Andy Miller's office, 7112 West Oklahoma Place, Kenneth, Washington, 99336, 509-73531, fax 509-736-3066.